yung ating discussion tungkol sa 30-0, mga kabatas natin. Attorney Libayan versus Raffy Tulfo in action. Ito po ay isang copyright infringement case. At mga kabatas natin, ang nangyari nga ay na-dismiss po yung 32 counts. No, na final ng Raffy Tulfo in action na copyright infringement laban sa akin. Okay? Ngayon, mga kabatas natin, ano ba yung natapos na natin? Natapos na natin i-discuss, mga kabatas natin, yung pag-file ng Raffy Tulfo in action ng motion for inhibition at saka motion for reconsideration, at ako naman ay nag-comment tungkol doon. Okay? Ang gist nga doon, sinasabi ng Raffy Tulfo in action na meron parang bias, mga kabatas natin. No? Sinabi ko naman na wala. Okay? At nagbigay ako ng mga dahilan, no, kung bakit wala at kung bakit tama yung ginagawa ng korte. Yung kabila naman, yung Raffy Tulfo in action naman, sinabi nila o nagbigay naman sila ng mga errors o mga pagkakamali na maaaring nagawa ng judge. Ito nga, mga kabatas natin, sabi niya, both motion for voluntary inhibition and the motion for reconsideration are filed at the same time herein. Therefore, it is imperative to resolve them simultaneously to prevent any undue delay that may aggravate the injustice already present in these cases. Okay, so mga kabatas natin, makikita nyo dito na yung court, mga kabatas natin, ay actually nire-recognize na merong mga injustices. Okay? Tsaka ngayon, mga kabatas natin, ang omnibus resolution kasi, mga kabatas natin, bakit omnibus ang tawag dyan? Kaya omnibus resolution yan kasi pangkalahatang resolution ng korte doon sa mga pending na mga incidents sa kanya. Ito nga, yung motion for inhibition at yung motion for reconsideration. Okay? So, tignan nyo. Yan, mga kabatas natin. Delay that may aggravate the injustice already present in these cases. Since again, the injustice in these cases are very apparent. Whew, ang bigat, no? The injustice in these cases are very apparent. Yung injustice, sobra na naman daw, mga kabatas natin, sabi dito. Very apparent, kitang-kita. O sabi, the court had examined the said omnibus resolution and found that the arguments of the prosecution in the motion for reconsideration had raised no new issues. Okay, ano bang dapat kasi mangyari dito? Dapat kasi, if you will raise a motion for reconsideration, mga kabatas natin, you will raise new issues. Ano ba yung mga new issues? Mga bagong pamantayan, mga bagong argumento para yung korte i-reconsider yung kanyang ginawang desisyon na. Kapag naman kasi, mga kabatas natin, inulit mo lang yung mga dati mong argumento o kaya yung mga argumento na ginawa mo ay ginawan na ng resolusyon ng korte, hindi na bibistahin ulit ng korte yan kasi nga tapos na. Okay? Ngayon, sabi niya ganyan, mga kabatas natin, indeed, the court had already fully discussed the issues in the assailed 19 April 2024 omnibus resolution. At any rate, the court will strive to simplify further the very basic matter. So, sinabi ng korte dito, mga kabatas natin, no? Simple na nga o basic na nga yung matters na nandiyan. Sabi ng korte. Pero sige, susubukan pa rin ng korte na i-simplify yung mga basic, very basic matter, mga kabatas natin. Very basic. Nakikita nyo ba yung ginagamit na vocabulary o yung languaging na ginagamit ng korte dito? Diba? Tignan nyo, mga kabatas natin. At the outset, the prosecution must be aware of their misapprehension of facts herein. They allege that probable cause was already determined by the same court. They keep on mentioning the same court in their allegations. Who are they referring to by the same court? Clearly, it is not the undersigned as they cannot even correctly spell her name in their motion. Alam nyo, mga kabatas natin, no? Payo ko lang. Hindi lang naman sa korte ito, kundi sa lahat. No? If you will write to someone, if you will talk to someone, especially if you will write to them, no, make sure na you get their names spelled correctly. Bakit, mga kabatas natin? Siyempre, it's a matter of respect din. Okay? Even your co-counsels. Okay? Kahit galit na galit kayo sa co-counsel nyo, kailangan nyo pa rin respetuhin sila. Ang pinaka-basic kasi na form of respect is to know the name of the person and to spell it correctly. Okay? Yan nga mga kabatas natin, no? They cannot even spell correctly her name in their motion. To clarify, sabi, this court has a presiding judge and an assisting judge. The finding of probable cause was embodied in the 07 December 2023 order issued by the assisting judge in criminal cases number 7153 to 7154. Therefore, this court, the presiding judge, did not determine the existence of the probable cause in these 32 cases before the issuance of the assailed omnibus resolution. Ang pinaglalaban kasi dito, mga kabatas natin, no, nung Raffy Tulfo in action, tapos na yan. Meron ng probable cause na dinetermine yan. Yun yung pinaglalaban nila. Pero anong sinabi ng korte dito, mga kabatas natin? No? It's a misapprehension of facts. Sa tingin ko nga, hindi nga misapprehension of facts yan. Pinipilit kasi nila na may probable cause na according to the two cases na nauna. When in fact, like I told you, mga kabatas natin, different cases, different case numbers, you treat them differently. They may be consolidated, mga kabatas natin, no? They may be consolidated, but in the end, kapag magkakaroon ng conviction, mga kabatas natin, bawat kaso, o kaya kung magkakaroon ng acquittal, bawat kaso pa rin, mga kabatas natin, hahatulan yan ng korte. So like for example, dun sa 32 cases na yon, ang mangyayari dyan, case number 1. Case number 1, acquitted. Case number 2, acquitted. Case number 3, acquitted. Case number 5, guilty, beyond reasonable doubt. Pwedeng maging ganun. Hahatulan ng judge yung bawat kaso na yan. Ang ginagawa kasi ng Raffy Tulfo in action dito, parang sinasabi nila sa korte na parang tapos na yung issue tungkol sa probable cause. Sinasabi ng judge dito, hindi pa. Okay? Sabi niya ganyan, therefore, this court, presiding judge did not determine the existence of probable cause because these 32 cases before the issuance of the assailed, in these 32 cases before the issuance of the assailed omnibus resolution. Yan, sabi ni Kayo, buti hindi naging lawyer si Raffy Tulfo kundi lagi kang magkakamali sa middle name at birthday. October 15. Sa tingin ko, parang magugustuhan niya pag nagkakamali ka. Di ba? Yun. Ngayon, sabi ni Teacher Viola Vlogs, malapit nang sabihin ng korte na ignorance of the law na talaga para sa mga 100 abogado. Hindi naman siguro. Kahiya naman siya. Hindi naman siguro. Mababatas pa naman. Yung pala mang bubutas. Naku, mapaplaswanan ka. Teacher Viola Vlogs, nagbablog ka ba? Naku, mahilig si Raffy Tulfo magkaso sa mga small vloggers. Tandaan nyo. No? Kung sino-sino na ang sinisisi, lahat may maliban sila. Siyempre maliban si Raffy Tulfo. Diba? Each of those can get you convicted, correct. That's why each of those should also be determined personally by the judge kung merong probable cause o wala. Walang pakyawan. Okay? Walang pakyawan. Ganun yon. Yun yung pinapaliwanag ng korte dito. Walang pakyawan. Okay? +1 ka, ma'am. Lagot. So, let's go. Sabi niya, the fair use content is patent and clear. It is shown by the very evidence of the prosecution. There is no way of rebutting it by any other contrary evidence. Yun kasi yung pinaliwanag na rin ng korte doon eh. Ang ebidensya dyan, yung video mismo. Yung video ang magpapakita kung fair use yun o hindi. Ano pa bang kailangan yung i-present? When in fact, mga kabatas natin, as you will know, dito sa kaso na pending, itong dalawang natira, yung 5-3 at saka 5-4, mga kabatas natin, pareho rin lang. It's the same banana. Even the evidence, it's the same banana. Walang nadagdag, walang kulang. Nung yung mga ebidensya nila sa prosecution, nung present nila ito sa prosecutor's office, okay? Yung pa rin ang ipepresent nila sa korte. So what do you need more? What more do you need? Diba? O sabi niyang ganyan, Honorable Jamie B. Santiago had found fair use. Honorable Maria Paz Reyes Izon does not deny fair use. No other judge can hear it in Taguig. Any other judge in the Philippines will find fair use is patent. Any other judge. The inhibition is patently a forum shopping and dilatory tactic. To condone it is to allow harassment of the innocent by the powerful. The Supreme Court dissuades it by Supreme Court Administrative Order number 62/2020. It is a fruitless endeavor. So is the motion for reconsideration. Ang sakit, no? Ang sakit. Honorable Jamie B. Santiago had found fair use. Honorable Maria Paz Reyes does not deny fair use. Yung si Honorable Maria Paz Reyes Ison, yun yung bagong judge doon sa dalawang kaso. Hindi niya dinideny daw yung fair use. Pero sinasabi niya kasi it should be threshed out in a full-blown trial. Pero fair use is not denied. No other judge can hear on it in Taguig. Any other judge in the Philippines will find fair use is patent. Isipin nyo, kahit sinong judge sa Pilipinas sasabihin, obvious ang fair use. The inhibition is patently a forum shopping and dilatory tactic. To condone it is to allow harassment of the innocent by the powerful. Goodness. Ha! Nakakakilabot. Nakakakilabot, mga kabatas natin. More so, when the motions are replete with misleading and libelous allegations in violation of Canon 2, Section 8 of the Code of the Professional Responsibility and Accountability as follows. A lawyer should at all times act with propriety and maintain the appearance of propriety in personal and professional dealings. Observe honesty, respect, and courtesy, and uphold the dignity of the legal profession, consistent with the highest standards of ethical behavior. Section 8, prohibition against misleading the court, tribunal, or other government agency. Oh my goodness. A lawyer shall not misquote, misrepresent, or mislead the court as to the existence or the contents of any document, argument, evidence, law, or other legal authority, or pass off as one's own ideas or words of another, or assert as a fact that which has not been proven. Sheesh! Sabi ni Egay, sheesh! Sakit nun! The rule on the voluntary inhibition of the judge is provided for in paragraph 2, section 1 of Rule 137, Rules of Court, to wit. Disqualification of judges. No judge or judicial officer shall sit in any case in which he or his wife or child is pecuniarily interested as heir, legatee, creditor, or otherwise, or in which he is related to either party within the 6th degree of consanguinity or affinity. Ito yung tinatanong ni Ricul, mga kabats natin. Yung affinity. Doon sa incest, it's consanguinity. Okay? Dito, mga kabats natin, 6th degree of consanguinity, 6. Bibilang ka ng 6. Or by affinity. Kung may kasal-kasal, may relationship. Okay? Or to counsel within the 4th degree, computed according to the rules of the civil law. Ano sinabi ko sa inyo, no, paano computed dito? No? Start doon sa tao, umakyat ka doon sa common ancestor nila. Tapos, pag meron na silang common ancestor na tinamaan, bumaba ka na. Okay? Or in which he has been executor, administrator, guardian, trustee, or counsel, or in which he has presided in any inferior court when his ruling or decision is the subject of review without the written consent of all parties in interest, signed by them and entered upon the record. A judge may, in the exercise of his sound discretion, disqualify himself from sitting in a case for just or valid reasons other than those mentioned above. It must be stressed sabi ng korte. However, that said rule does not give judges the unfettered discretion to decide whether to desist from hearing a case. The Supreme Court in the case of Kilos Bayan Foundation et al. Versus Leoncio M. Hanolo Jr. et al. Emphasized the inhibition must be based on just or valid reasons to it. Sabi niya. Hindi naman kasi basta-basta inakusahan mo yung judge ng impartiality, mga kabatas natin, no? Dapat mag-inhibit na siya. Ito pa rin yung sinasabi, no? In keeping with the tenet that judges should not only act with fairness, independence, impartiality, and honesty, but should also be perceived to be the embodiment of such qualities, the court added the rule of voluntary inhibition in 1964. In outlining the genesis of the provision, the court narrated, in Umale versus Villaluz, the court traced the history of the second paragraph of the above-quoted provision, which had been added only as an amendment to the rules of court in 1964. Prior to that year, the question on whether to take cognizance of the case did not depend upon the discretion of the judges not legally disqualified to sit in a given case. If those concerned were not disqualified, it was their official duty to proceed with the case or else risk being called upon to account for their dereliction. Anong sinabi dito? Sinabi ng korte, mga kabatas natin, na sinabi ng judge dito, na kapag hindi ka naman disqualified, kailangan ituloy mo. Kailangan ituloy mo yung kaso. Otherwise, dereliction of duty yan. Sabi ng korte, okay? They could not voluntarily inhibit themselves on grounds of prejudice or bias, extreme delicacy, or even if they themselves took great interest and an active part in filing of the case. Gutierrez versus Santos and Del Castillo versus Habelona paved the way for the recognition of other circumstances for disqualifications, those that depended upon the exercise of discretion of the judges concerned. Sabi niya, while the second paragraph does not expressly enumerate the specific grounds for inhibition and leaves it to the sound discretion of the judge, such should be based on just or valid reasons. Dapat tama naman. Tama yung reasons mo, dapat valid siya. The import of the rule on the voluntary inhibition of judges is that the decision on whether to inhibit is left to the sound discretion and conscience of the judge based on his rational and logical assessment of the circumstances prevailing in the case brought before him. It makes clear to the occupants of the bench that outside the pecuniary interest, relationship, or previous participation on the matter that calls for adjudication, there might be other causes that could conceivably erode the trait of objectivity, thus calling for inhibition. Sinasabi rin dito, mga kabatas natin, na yung mga judges, no, they can voluntarily inhibit themselves if they think talaga na they cannot dispense justice well. Okay? Ngayon, this is to betray a sense of realism for the factors that lead to preferences and predilections are many and varied. In the final reckoning, there is really no hard and fast rule when it comes to the inhibition of judges. Each case should be treated differently and decided based on its peculiar circumstances. So, hindi automatic na pag sinabing mag-inhibit ka, inhibit na. The issue of voluntary inhibition is primarily a matter of conscience and sound discretion on the part of the judge. It is a subjective test, the result of which the reviewing tribunal will not disturb in the absence of any manifest finding of arbitrariness and whimsicality. The discretion given to judges is acknowledgement of the fact that they are in a better position to determine the issue of inhibition, as they are the ones who directly deal with the parties litigants in their courtrooms. Impartiality being a state of mind, there is thus a need for some kind of manifestation of its reality. So sinasabi dito, mga kabatas natin, na hindi porke naiisip mo o inaakala mo, yung judge ay impartial, pwede ka nang magpa-inhibit agad. Dapat meron kang malakas din na ebidensya o kaya basehan. Okay? Ngayon, mga kabatas natin, in order to provide good, sound, or ethical grounds or just and valid reasons for inhibition, bare allegations of bias and prejudice are not enough in the absence of clear and convincing evidence to overcome the presumption that a judge will undertake his noble role to dispense justice according to law and evidence and without fear or favor. In Gotchan versus Gotchan. The court elucidated further. Verily, the second paragraph of Section 1 of Rule 137 does not give judges the unfettered discretion to decide whether to desist from hearing a case. The inhibition must be for just and valid causes. Sabi niya dito, the court has to be shown acts or conduct clearly indicative of arbitrariness or prejudice before it can brand them with stigma of bias or partiality. Ito rin kasi mga kabatas natin, no? If, like for example, you are branded with bias or partiality, okay? Tapos ininhibit mo yung sarili mo. Ang parang logical consequence nun, you also believed yourself that you are biased or impartial. Kung walang ebidensya na pinakita. Pero kung may ebidensya na pinakita, mga kabatas natin, you have to inhibit yourself. Di ba? Ito. In a string of cases, the Supreme Court has said that bias and prejudice to be considered valid reasons for the voluntary inhibition of judges must be proved with clear and convincing evidence. Ito, padagdag na lang ito. Okay? The prosecution's sole ground for the court's inhibition is that the text of the said omnibus resolution exhibited gross partiality, prejudice, and bias. Nasaktan yata sila. Any impartial aficionado of the law of copyright infringement, of free speech, and of freedom of expression will be dumbfounded by said allegations of a private complainant doing business as a media practitioner. Ang sasakit naman kasi yung mga sinasabi dito. Ouchie. Any impartial aficionado of the law of copyright infringement, of free speech, and of freedom of expression will be dumbfounded by said allegations of a private complainant doing business as a media practitioner. Ang negosyo naman kasi ng Raffy Tulfo in action, mga kabatas natin, di ba media daw? Ouchie. Devoid of onion skin delicacy as a journalist should be, the rulings of the court therein would be appreciated by anyone well-versed in literature and logic to be merely based on the exercise of logic and law with cold and precise impartiality. I agree. Mga kabatas natin, how will you rebut? How will you say otherwise doon sinabi ng korte doon? You cannot. Because it was backed up by logic and law with cold and precise impartiality. Like I told you, mga kabats natin, I was surprised by the decision of how perfect it is. It's so perfect. Ang ganda ng coherence. Ang gaganda ng mga sinite ng jurisprudence. Pati yung mga sinite tungkol sa literature and logic. Sabi ni Kayo, huwag ka magyabang na logician ka. Huwag ka magyayabang na logician. Sabi ba ni Fabrian? Alam niyo mga kamatas natin, alam niyo, if you are a logician, the logic already is a very powerful tool. Yung logic mo, you arm it with facts, you arm it with the law, oh, you can be invincible. Logic is very important. Everyone should learn it. Galit pa naman sila sa logic. Logician. Nagpag-aalata ka, Oliver Sanyano. Iba yun. Logis yun. Logis. Ayaw daw logic. Gusto backer yan. Patay tayo dyan. Logic is geared towards the truth. Sabi no nonsense. Kaya kahit di ka batas si judge, same logical conclusion. Yeah? based on the exercise of logic and law with cold and precise impartiality. Putik yan. To emphasize without fault of being repetitive, the court had painstakingly viewed, summarized, and tabled all the videos. Nakita nyo naman yung ginawa ng korte doon, mga kabatas natin. Hindi lang siya basta-basta nag-decide. View niya, pinanood niya. Sinayang niya yung oras niya, mga kabatas natin. Yung korte, sinayang niya yung oras niya para manood ng video ko. Sinamarize ito at tinable pa. Herein and had duly researched all the laws and jurisprudence necessarily herein. The videos are what they are, evidence of what the private complainant actually did and what the accused actually did. No amount of verbiage, drama, and hyperventilation will reverse what the parties did. Yun nga. We don't need any other evidence. Yun nga ang punto dun eh. Ano bang gagawin mo pa? Wala na. Bakit? Meron ka bang mispipresentang ebidensya na mas malakas kesa dun sa mga videos mismo? Wala. That is what the court is saying here. Yun na yung videos na yun. Sabi niya, res ipsa loquitur. Anong ibig sabihin nun? The thing speaks for itself. The evidence of copyright infringement is the videos themselves, and they speak for themselves also. Kahit anong kwento mo, hindi yan. Mas mataas pa sa ebidensya ng video mismo na nandudoon na sa kamay ng korte. Sabi niya, it's just following the logical consequence. So, no partiality doon. Logic has rules of inference, hindi yan based sa interpretation or semantics. If I was Artie and his ships, I'd be so embarrassed. Sabi nga nila, ewan ko, sinasabi ba nung mga vloggers niya na mag-aano daw sila, magsu-Supreme Court. I would love to. I would love for you to go to the Supreme Court. Let's see what the Supreme Court will say. Actually, I even encourage you. Para naman, may contribution naman ako sa Supreme Court. Ay. Sabi ni Enbray, welcome sa batas natin, Shadow Judge. Yun nga nakakahiya eh. Pati yung judge parang naharas. Sabi ni Miss Rosalie, take note, all caps, so parang sinigawan sila sa document. Logician, sabi ni Marky, logician tapos magician kasi. Nakatakbo na, convicted involving moral turpitude. Very comprehensive yung judge. What can we say? What more can we say? Bring it to the Supreme Court. Petition for certiorari or certiorari. Let's go. The court merely called the truth. It had seen and pronounced it. The truth hurts, especially on those too blind or too stubborn to look on their reflection when mirrored by the court. This is what a court of justice and equity does. Hold up a mirror to those who appear before it. Ha! Grabe! Tuloy natin dun sa kabila, mga kabatas natin. No? This is the epilogue. Nag-file ba sila, attorney? Wala pa naman akong alam. Ewan ko. Kasi malalaman nyo siguro naman. Yung mga vloggers naman yan, madaldal kung magpa-file yan. Pero I want them to file. Para may GR number tayo. Kayo naman. Hi! Para may screen na rin yan sa SC. Sabi nila lalo na perfectly articulated. Ang galing nga eh. Hold up a mirror to those who appear before it. Anyway, tuloy natin doon sa kabila mga kapatid natin. This is the epilogue. No? Ang galing, ang ganda. Maraming salamat mga kapatid natin. At syempre, tulad lagi sinasabi, matulog po tayo na maimbing dahil alam natin na natutulog na maimbing, siya yung laging panalo. Paalam po, pansamantala.